Hello, I'm Hani Bushra. I'm an immigration attorney based in Huntington Beach, California. Today is August 5th, 2019, and this is a monthly update about all the things that are going on in the world of immigration. Not necessarily everything, but the things that I work with. And I just wanted to give you an update about what's going on in the immigration world this last month and what's expected to happen in August of 2019. I want to talk about three different areas. I want to talk about green cards through family petitions or people who are waiting for the green cards here in the United States. And then I want to talk about citizenship and the updates going on in citizenship applications. And then finally, updates regarding asylum. For green cards, people who are waiting for the green card here in the United States, we are seeing extensive delays in getting a green card interview. And one of the main reasons that this is going on is that the number of green card interviews are being scheduled has expanded. So there's categories that never used to be interviewed for green card, and those are things like employment green cards for older parents, especially mothers, because you can easily prove the familial relationship through birth certificate. But these categories did not have green card interviews before, but now they're having. And the more people who are doing green card interview, who have to do a green card interview, means there's going to be a delay or extensive delays in you getting your green card interview. The other issue that we're noticing is that there are a lack of resources directed towards conducting green card interviews. So, for example, what we're seeing right now is more and more of people, sadly to say, USCIS employees who are asked to volunteer to work for the Border Patrol or to work for CBP, Customs and Border Patrol. And if your boss says, we'd like you to volunteer your time, you can bet yourself that you're most likely going to be ignoring some of the work you're supposed to be doing, which is green card interviews, and going and trying to get, for instance, your boss to be very happy with you and volunteering your time with Border Patrol or CBP. The other thing that we're noticing in green card interviews is that there is an emphasis on the affidavit of support. So if you're getting your green card on the basis of a category that has an affidavit of support requirement. So for instance, you're getting it from your spouse, you're getting it from your parents, or if you are a parent, getting it from your child. There's a strong emphasis on the affidavit of support. You're being warned in the interview that you cannot be taking any aid. If you are granted a green card, you're asked about your extensive history. If you are in the United States, if you had received any aids or any help from the government. So there is a big emphasis on that, and that's part of what is driving this administration, and we're seeing a big drive with that. The other thing that we are seeing in the green card interviews with the affidavit of support is sort of asking if anybody that's related to you, like your child, who's a US citizen or something like that, is receiving aid. I don't, and I think it's documenting this later on for citizenship. There's nothing that can be actionably done with that right now. But we know that there is a rule out there called the public charge rule that has not been yet implemented. And the idea of it is to restrict people with green cards and to restrict people to get from citizenship. I want to just make sure that you know that there's two categories of green card applications that do not require affidavit support, and those are people who receive diversity lottery and people who also receive um, uh, green card through their asylum status. Two other things in the green card world. Number one, our office has been very successful in um, making sure that people who are um, here in the United States living for many, many years, sometimes on non-immigrant status, like a student visa, or who have applied for asylum and their asylum is pending in the asylum office and have been there for years, and they applied for the asylum before their status before that, like if they came on a visitor visa, their status did not expire and they applied for asylum. And then suddenly they have a chance to immigrate to the United States, whether through an employment petition, whether through a family petition or diversity lottery. We've been able to get them the green card in the United States without them leaving. There's something called the matter of LK. It's a case that talks in the negative in that scenario. It talks about people who were in the asylum office but ended up going to immigration court and they won the diversity lottery when they were in immigration court, and they argued that because we are in immigration court and we're still under, the authority of the rights of the immigration process or in the immigration process, we can get our green card through the lottery in the United States. That, of course, was denied in the matter of LK. And in the matter of LK, there's a couple of sentences that said if you had been in the asylum office, pending in the asylum office, then technically you would have been able to apply for your adjustment because the delay in getting the interview is the fault of USCIS. So for a while, this was not accepted by USCIS as an explanation, but we've been getting a lot of successes lately in convincing officers. We've convinced officers in Sacramento, we've convinced officers in Fresno, convinced officers in Orange County, Los Angeles, even New York. And so different areas, we've been able to convince officers that the matter of LK is applicable to people who had pending asylum cases and had not been interviewed yet, but then suddenly have a way to come to the United States and immigrate to the United States. That's the main issue that I want to talk. Oh, the other thing about green cards I want to also update you with is that if you are a green card holder and you have a spouse or a child under the age of 21 and they are here in the United States, now is the time to apply for them because they can apply for both a petition and a green card at the same time if they're here in the United States, and they can wait for their turn to come. The application process is open for people who are married to a green card holder. They don't have to wait for the I-130, or which is the petition itself, to be approved in the beginning. They can just apply for the green card and the petition at the same time, and that's for the month of August. We don't know if it's going to be available for the month of September, but if you have a chance to do that, if you have a spouse who is here on a student visa, for instance, and waiting for you to become a citizen, or if you have a spouse who came and visited you with a visitor visa, now is the time to do that. It's in your advantage. This is something that happens every 4 or 5 years where there is an ability to do that instead of waiting for a petition to be approved and then waiting for a certain amount of time for a visa to be available. So please go ahead and take advantage of that. If we can help you, please contact us. I want to talk about citizenship applications. Citizenship applications, or that's the second category of things I want to talk about. They are taking much longer because there's a lot of people applying for citizenship, because a lot of people, of course, are freaking out because of some of the things they hear in the news about green card holders and what can happen to you as a green card holder. I want to talk about two big things that are going on in the world of citizenship. Number one is that if you are seeking a medical exception to taking the civics exam and or the English exam, which is something called the N648 form, there has been a change in how the N648 has to be filed and when for it to be filed, and that change is catching a lot of people by surprise. For now, starting February 12, 2019, if you are filing an naturalization application, N400 application for citizenship, and you are planning to seek medical exception to taking the test in English, or taking the test, or taking the civics exam, you have to file the form and the application, the N400 and the N648, the exception, together at the same time. We used to be able to take the N648 with us to the interview and have the officer look at it the day of the interview. That's not possible anymore. There is an exception, of course, for, you have to explain the emergency for why you didn't file it in the first place. But for now, the policy is that both of these things have to go together at the same time. And a lot of people who are accustomed to doing things the old way will, be, rudely surprised when they go and find out that their N648 is not accepted just because it was filed after they filed their naturalization application. The N648 is getting a high rate of denial because of two things, honestly. Number one, of course, there's restrictions on them, and I think there's memos, internal memos saying, make this harder for people to get that exception. But I think the other issue that we're having with N648 is that a lot of doctors are not writing proper N648 forms. They're just, writing gibberish, to be honest, and sometimes even not following the instructions in the form. And when that happens, it's easier for an officer to deny it. I know that when we get a case that requires an N648, we work closely with the doctor that is going to write the report, and we have them edit the N648 maybe sometimes even multiple times just to make sure that the officers accept it, and not we don't have problems and the technicalities of the form itself. Now let's go to the area of asylum. Right now, our office in July and in June and August has been receiving interviews in Los Angeles, San Francisco, Miami, Chicago, Arlington, Virginia, and New Jersey. So these offices are conducting interviews right now. Arlington is a weird office because they are scheduling people, but then they go ahead and cancel them. Okay, and we've seen a number of cancellation happening also in Los Angeles and in San Francisco due to lack of resources. We think that, or we've been hearing a rumor that the number of interviews is going down, especially that a lot of resources are being shifted to the borders to interview people who are coming to the borders to do the credible fears. So, for instance, there is a rumor out there, not a rumor, but it's from actual practitioners in the field who have noticed that the interviews, for instance, in the office in New Jersey, has been reduced from 84 interviews per day to almost 20 interviews a day. Number two, we're also seeing emphasis on interviewing cases that have 1 year issues, and those are cases that are people who filed for asylum that had been in the United States for more than 1 year. Their asylum offices are going back and picking those cases and interviewing them. And I think it's also a way to weed out cases that have just been filed just for the sake of getting a work permit. We are seeing a number of approvals, especially in the field that I work in or in the countries that I work with, a high number of approvals in Christians from the Middle East or people from the Middle East. But we're also seeing some changes in the laws and the regulations that could have effect on future asylum cases. We're seeing this administration is unable to change the law, but it's able to change the regulations and the interpretation of the law. And that's what they're resorting to finally, because they are unable to convince Congress to take a stand with them and change the laws and make it the way they want it, so they change the way the law is interpreted. So one of the things we've happened recently in the last 2 weeks is the idea that you cannot prove you are fearful to go back to your country because of a harm that could happen to the family, your family. It's something called a particular social group definition, which is the idea that there are certain groups in society that are distinct from other groups. For instance, people who care about the environment or environmentalists. Okay, that could be a very strong group of particular social group that is separate from society. Family has always been recognized since 1985 as a particular social group. The administration came and said, no, it's not in our regulations. These cases are going to be litigated in court. I don't think it's going to win. But in the meantime, it's making things harder for people who go in and have a family-based claim. Somebody's targeting my family as a whole, or that I'm afraid because of what happened to a family member or something like that. That's going to make things a little bit harder. We're seeing a lot of questions about relocating within your country, the country that you're in right now, and we're seeing that some of these questions are not the country you're afraid to go back to. Some of these questions should be asked on the border cases, but we're also seeing them, asked a lot during the asylum interviews and not only in border cases. Finally, I just want to emphasize a point that for the longest time, people have thought of the asylum process as simply just going in and saying what happened to you and why you're afraid to go back. But the more this administration tries to restrict asylum, one of the techniques that it's using is making sure that people lose cases on technicalities, legal technicalities, things that would escape your minds as somebody who's not a lawyer. And so what my suggestion is for you is, if you can hire a lawyer who understands asylum to help you with your asylum case, please do. Because there are certain things that you feel like, oh, I shouldn't say that. But in the end, they end up making you win your case. Okay? And there are certain things that where you feel like, oh, I should say that, emphasize that, but have maybe sometimes even a negative effect on your case. It should not be revealed unless you're asked a question about them. And so a good story is not enough anymore. Okay? for um, uh, for your asylum case. So telling an officer about only what happened with you without clarifying how this applies to them, to you, to the laws, or how the harm that happened to you is a harm that should be protected under the law, could end up you losing your case on a technicality, and it's something that you don't want. If we can be of any help for you, please shoot us an email, send us your questions, leave us a comment, and we'll try our best to answer those comments as soon as we can. If you want to give us a call, our number's on the screen. And I really thank you for watching this video. And if you have any questions, please don't hesitate to contact us. Thank you very much.